Welcome, everyone. Thank you for joining us. Before the program starts, I'm going to go over some housekeeping matters. First, we acknowledge that this land, which is named for the Ute tribe, is the traditional and ancestral homeland of the Shoshone, Paiute, Goshute, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many Indigenous peoples and their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to partnership with the Native nations and urban Indian communities through research, education, and community outreach. Also, towards the end of this program, we will open it up for question and answer. Please use the Q&A and not the chat. We will be monitoring the Q&A, and if you see a question that is similar to yours, you can upvote that question and it will go through. Stay on the entire time pursuant to Utah Supreme Court rules to get your CLE credit, and we will send the bar the attendance list so they will know about your participation immediately, and we will get the CLE certificates out to you as quickly as we can. Now, it's my pleasure to introduce to you our presenters, Shaylin Heyman and Austin Ryder from Parr Brown, and I will throw it to you.
Thanks so much, Lori. We're so excited to be here today. By way of just brief introduction, Austin and I, we're both shareholders at Parr Brown. We're members of our firm's employment section. We represent both public and private employers almost exclusively on the management side. So we counsel employers on all manners of employment topics, discrimination, harassment, disability accommodation, leave issues, hiring, firing. We spend a lot of time on the phone every day with our HR clients. And then we also draft policies and advise on things like non-competes and non-solicits and do trainings and investigations. So we kind of do the whole smorgasbord. But for purposes of today, why we've been asked to talk about this is that we also help advise our employers on the Fair Labor Standards Act. We advise them on the front end with regard to questions, and we also help them litigate claims when those arise, including in class action contexts. So with that in mind, before we jump in, we're going to be talking about Helix Energy Solutions Group versus Hewitt. But I'm assuming that not everybody on this call lives, eats, sleeps, and breathes the Fair Labor Standards Act the way that Austin and I do. So just to make sure that everybody is on the same page, let's do a little bit of just background on what is the Fair Labor Standards Act. So when you hear somebody say that an employer has to pay somebody minimum wage, or that an employer has to pay someone overtime, we are talking generally about the Fair Labor Standards Act. So when it comes to overtime, there are some states that have specific state regulations, and some of them are more strict. California is my perennial example, but there are some others, including California. But for today, we're talking only about the federal Fair Labor Standards Act. That's the primary federal law that governs the wage and hour standards for most full-time and part-time workers. And that's in both a public and a private employment setting. That's 29 U.S.C. 201. This is a statute that's been around for a long time, since 1938. And it's the law that establishes minimum wage requirements, overtime pay requirements, record-keeping obligations, child labor restrictions, and there are a number of other workplace standards. The Department of Labor is the federal agency that administers and enforces the Fair Labor Standards Act through its wage and hour division. And the Department of Labor, they have issued a comprehensive set of regulations implementing the FLSA. So if you think I'm lying, like, this is my Bible, right? Yes, I still like paper. This is the regulations that I keep next to my desk at all times. And just for your edification, the Department of Labor also has a lot of guidance documents that are very helpful online in the form of FAQs. The Fair Labor Standards Act requires all employers to pay employees overtime pay, which is time and a half, if they work more than 40 hours in any given work week, unless the employee is exempt. So you may have heard the terms exempt versus non-exempt. That's where we're getting these terms. Now, Section 13A1 of the Fair Labor Standards Act It does provide an exemption from both the minimum wage requirements and overtime pay. And overtime pay is the thing that we're going to be focusing most on today. So as an employer, I'm exempt from having to pay an employee overtime for employees that are employed in bona fide executive, administrative, professional, and outside sales employee positions. And then there is also a separate exemption from certain computer employees. So for any of my aspiring lawyers that may be on this call, I don't want you guys to get excited that you're going to get a lot of overtime, because you're not. You're going to be performing work that requires the advanced knowledge and skill that falls into that professional employee exemption. Welcome to the world of exempt employee work. So to qualify for an exemption, under the three primary ones when we're talking about exemptions are usually three. We're talking about bona fide executive, administrative, or professional exemptions. So in order for an employee to satisfy those, an employee has to meet three tests. So the first test is a salary basis test. An employee must receive a predetermined amount for each week that that employee works, which is not subject to reduction because of variations in the quality or quantity of work performed. So that's the first test. You have to satisfy the salary basis test. The second test is a salary level test. So in addition to being paid on a salary basis, under the regulations, an employee also has to have a salary that exceeds a specified amount. Now, currently that specified amount is $684 per week. But you're going to hear a lot of discussion of $455 per week because that was the standard that was in place when the Hewitt case was decided. But for right now, it's $684, excuse me. So salary basis test has to be paid on a salary basis. Second, has to also exceed that threshold amount, currently $684, but used to be $455 until January of 2020. And the third piece is a job duties test. And that's going to focus on the nature of the employee's job duties. And I will tell you as a practitioner, when I'm dealing with Fair Labor Standards Act questions, 90% of the time, the areas that we're spending time is not the salary basis. It's not the salary level test. We're focusing in on this job duties test. What is the job duties test? Well, for each one of those types that I said before, executive, administrative, professional, they all have different requirements. But for the executive exemption, which is the relevant one today, we're talking about three prongs that have to be satisfied to meet that job duties test. First, the employee's primary duty must be managing the enterprise or managing a customarily recognized department or subdivision of the enterprise. CEO, COO, right? All of your executive C-suite folks, that and more. That's just a sort of stereotypical example. So that's your first element, managing the enterprise. The second is that the employee must customarily and regularly direct the work of at least two or more other full-time employees or their equivalent. And the third is that the employee must have the authority to hire or fire other employees, or they have to be in a position where their suggestions and recommendations as to hiring and firing, advancement, promotion, those types of things are given particular weight. So you don't have to actually have authority to hire and fire, but if you make a recommendation, it has to be given some pretty good thought in order to satisfy that job duties test. So that's currently what you need to be able to be classified as a bona fide exempt executive employee under the Fair Labor Standards Act. Salary basis test, salary level test, and also satisfying the job duties test. Now, I said before that the Department of Labor is the one that implements the Fair Labor Standards Act, and the Secretary of Labor has implemented a bona fide executive standard through two separate and slightly different rules. So the first rule is, I'll call it the general rule. The general rule applies to employees making less than $107,432 in total compensation per year. And that includes not only salary, but that's including commissions and bonuses and other forms of compensation. Now, for purposes of the Helix case, the standard in place back then was 100,000, but it's currently 107,432. I think it might be easiest not to confuse things. Just I'll refer to it as 100,000 for purposes of this webinar. It makes it easier. Inflation, folks. It went up to 107 in January of 2022. Okay, so that's the first rule. So the Secretary of Labor has said there's going to be one rule, a general rule that applies to all employees making less than, we'll say, $100,000. The second rule addresses highly compensated employees, or called HCEs. These are folks that are making more than, at the time of Helix, $100,000. Now it's people making more than $107,432. Wow, that's such a mouthful. Okay, under the general rule, employees have to meet the employees meet the executive exemption when they are compensated on the salary basis test, and they make at least, in prior to 2022, $455 a week, now $684 per week on a salary or fee basis. So that's the salary level test, and they manage the enterprise, direct other employees, and exercise power and power to hire fire, right? The things that I just previously talked about before. That's the general rule. However, there's this second avenue. And under that second avenue, the second rule for our highly compensated employees, the salary basis test and salary level tests still apply. But what the Secretary of Labor has done is they've said on the duties side, hey, I no longer have to satisfy all three of those elements, right? The managing the enterprise, directing other employees, exercising power to hire and fire. If I am so highly compensated, there's sort of like a presumption that I'm going to be a bona fide executive, I only have to regularly perform one of those responsibilities listed in the general rule. So, when I have a client that calls me and says we're talking about a highly compensated employee, inside my head, I'm thinking, oh, great, fantastic. This is going to make it easier for my employer to be able to classify this person as exempt so that I don't have to pay them overtime. Okay, last thing before we start diving into this Hewitt case. There are two other regulations that provide greater context to the salary basis test. That's an issue that Austin is going to talk about in Hewitt. So we have the CFR is 541-602A and 541-604B. And I'm going to do the same thing that the Supreme Court did, and I'm just going to refer to them as 602A and 604B. So we have 602A. That regulation states that an employee will be considered to be paid on a salary basis if the employee regularly receives each pay period on a weekly or less frequent basis a predetermined amount constituting all or part of the employee's compensation, which is not subject to reduction because of variations in the quality or quantity of the work performed. This is 602 is really just the same test that I had laid out to you before. 604B is the other regulation. It says that an employer, notwithstanding that general test that I just told you about, that an employer may base an employee's pay on an hourly, daily, or shift rate without violating the salary basis requirement or losing the bona fide executive exemption, so long as two conditions are met. So generally, I'm having to pay people on a salary basis, but I can do it on an hourly shift or daily basis if I do two things. First, the employer must guarantee the employee at least, in Hewitt times, $455 a week, now $684 per week, which is the minimum salary level, regardless of the number of hours, days, or shift works. Okay, pretty straightforward. And second, the promised amount must bear a reasonable relationship to the amount actually earned in a typical week. And they've clarified that that means that it must be roughly equivalent to the employee's usual earnings at the assigned hourly, daily, or shift rate for the employee's normal scheduled work weeks. So that's the general lay of the land with regard to this particular salary issue that I think gives you the basis to understand as we start jumping into this Hewitt case, where the court was going when it was looking really closely at the salary basis test. So lots of regulations, super fun. I encourage you to get your own CFR Bible, yes, and mark them up. But in the interim, with that background in mind, I will go ahead and turn the time over to Austin so that he can talk to you about the facts in this case and what the majority had decided.
Thank you all for having us be able to speak with you today. It's a privilege. I'm excited to talk about this case. I think it's very interesting. It was a long-awaited decision with a lot of buzz surrounding it. And so Shaylin said, overtime, it's time and a half if you work over 40 hours in a work week. And I try and think about, like, why is this overtime rule in place anyway? Why do we have it? What are they trying to do? And there's kind of like two reasons I think that are stressed in this opinion. They're oppressive working conditions. You don't want people not being compensated enough for working too many hours. And then the second is to incentivize employers to hire more people. So I think you're going to see the administration, their bias is going to be towards having more people fall within this overtime category. So kind of like maybe through that larger conceptual lens, it helps us understand what happens in this opinion. And then to step back and you can think, okay, it may seem surprising that somebody that is very highly compensated, hundreds of thousands of dollars, is still considered a non-exempt employee under the FLSA. And as we get into like the actual text and maybe some of those policy reasons underlying the statute, maybe consider whether it's all that surprising to you anymore. So this opinion, again, is Helix Energy Solutions is the employer, and then a guy named Michael Hewitt is the respondent in this appeal to the United States Supreme Court. It was argued in October 2022. The decision came out in February of 2023 on February 22nd. The opinion, the majority opinion, is authored by Justice Kagan. It's a 6-3 split. There are 3 dissenting justices, and Shaylin is going to talk about those dissents. Very interesting. But it was Gorsuch, Alito, and Kavanaugh. Alito and Kavanaugh have substantive dissents. Gorsuch believes that the cert shouldn't have been granted. It was improvidently granted. So the issue that came before the United States Supreme Court is whether a high-earning employee, one of those employees that Shaylin just discussed, who is compensated on a salary basis when his paycheck is based solely on a daily rate, which means that he receives a certain amount if he works 1 day in a week, twice as much for 2 days, 3 times as much for 3 days, and so on. And the court says no, an employee is not paid on a salary basis and thus is entitled to overtime pay if they are a daily rate worker. So the facts, what is this case based on? It's the time period from 2014 to 2017. So that's why the numbers that Shaylin told you are lower than today's. You'll hear that number 455 a couple times. But Hewitt, the respondent, worked for Helix as a tool pusher on an offshore oil rig and had a pretty demanding schedule. So he often works 12 hours a day, 7 days a week, for 28 days straight. And that is called a hitch in the industry. So that ends up being 84 hours a week. And then he's got 20 days off before he starts his next hitch. And he reports to the captain on the oil rig. He supervises about 12 to 14 other workers. So, these facts are salient when we're thinking about the duties that Shaylin mentioned. And Helix pays this guy, Hewitt, on a daily rate basis with no overtime compensation. And that daily rate changed over the course of his employment from 2014 to 2017, from like $963 to $1,341 per day. His paycheck, he received it every 2 weeks, and that's going to be important for some of the arguments that Helix makes. And his paycheck amounted to his daily rate times the number of days that he worked in that 2-week pay period. So if he worked only 1 day, his paycheck would total, like at that range's low end, $963. If he worked all 14 days in that 2-week pay period, his paycheck would be $13,482. And under this whole compensation scheme, he makes more than $200,000 annually. So that's the context in which we look at this framework that Shaylin set out, that Hewitt says, okay, this violates the FLSA. I should have been paid overtime as a non-exempt worker, given that I was a daily rate worker. And I think what's important is some of the stuff that is off the table. It really narrows this case down. And so the only question, like Shaylin laid out the 3 different tests, right? There's the salary basis test, there's the salary level test, and then the job duties test. And so I think here, the only question is whether Hewitt was paid on a salary basis. Again, and that's under that section 602A of the Secretary of Labor's federal regulations. They've taken everything else off the table. So the parties agree that Hewitt was exempt only if he was a bona fide executive. They agree that under the regulations, a high income employee counts as an executive only if he's paid on a salary basis and it's above the requisite level and he performs at least one listed duty. So they basically say salary level test is satisfied, job duties test is satisfied. We're not arguing about those. It's just solely the salary basis test that's at issue. And then Helix narrows that even further. And we're going to talk about that as well. So how do you satisfy the salary basis test? I think Shaylin said that there's two different ways to do that. Under the federal regulations, there's that 602A, and then there is the 604B. So 602A, which she already quoted to you, and I'm going to just reread it because the majority spends a lot of time on a textual plain language argument, requires an employee regularly receives each pay period on a weekly or less frequent basis. So that's the minimum. You can't be getting your paycheck more often than a week or more. A predetermined amount constituting all or part of the employee's compensation, which basically can't vary depending on the amount of work performed. And then subsection 1 clarifies that an exempt employee must receive the full salary for any week in which the employee performs any work without regard to the number of days or hours worked. And then 604B basically says if you don't satisfy that 602A test, the only way that you can be a daily rate worker is if you get you can have your daily rate, but then in addition to that daily rate, you have to have some guaranteed amount of salary that then also has a reasonable relationship to the amount that you would get if you did have a regular salary, regardless of the numbers of hours, days, or shift worked. So it has to be a reasonable relationship between the guaranteed amount of salary and the actual amount actually earned. So I think the court notes also that, okay, Helix concedes that 604B is not satisfied. So they can't satisfy the salary basis test there. And that is because there's no guaranteed minimum weekly amount at all for Hewitt, much less a guaranteed amount that had any reasonable relationship to his weekly earnings. So that leaves it hinging solely on 602A. And the court there goes like straight textualist and says that the language is clear. Based on that, they look at Webster's dictionary definition of salary as kind of a stable, regular, predetermined amount of a predictable stream of pay. And basically say that the pay rate paid to Mr. Hewitt cannot satisfy the salary basis test. It's just inconsistent with 602A. If you're paid on a daily rate, there's no way that you can satisfy 602A because it requires that that pay cannot be subject to fluctuation based on the number of days you work. And for him, it changed if you worked 1 day, if you worked 2 days, if you worked 3 days, whether he was sick a day. So incompatible with what his job was. And Helix says, oh, well, wait, okay, look at this word receives in the 602A language. So it says that the employee regularly receives each pay period on a weekly or less frequent basis, the predetermined amount. So they say that happened every 2 weeks, this guy received a paycheck and it was a set predetermined amount. And in that, it was always over $455, which was the salary level. So based on that, they say that the elements are satisfied. He received it regularly every 2 weeks, set amount. And the court said, no, that isn't what they're talking about. The regulation is not talking about pay frequency. It's talking about the unit or measurement or calculation of the pay. whether it's a day or an hour, but not a weekly pay period. So then with that gloss, I think they go on again to say that if 602A, could apply to a daily rate worker, then that wouldn't make sense because that's what 604B does. And Helix tries to say that 604B doesn't apply solely if you have a highly compensated employee. You just take it off the table and it doesn't matter. And they say, no, you can't do that. That's no part of the test that Shaylin talked about, that it doesn't apply. And you have to read them consistently. That if 602A by its very language excludes all daily rate workers, then the only way that you can get there is through 604B. And you read those in tandem, and that's how it works. And if you can't satisfy 604B, then you're out of luck. And then in addition to that, I think there's a lot of policy arguments that Helix raises, and there's three main ones. I think the first is that you're giving windfalls to these highly paid employees. This guy is getting over $200,000 a year, and now he's going to get all this overtime. And I saw something about the calculation of what is it potentially at issue, and it's staggering. So if you think about this guy Hewitt had 84-hour per week schedule, like we talked about, that's 44 hours of overtime. And if you take that at like $1,000 a day, $175 an hour, that means he's owed a whopping $11,550 per week in overtime. So assuming it's 28 days on, 28 days off schedule with a hitch, that means back wages of $300,300 per year. And then on top of that, like assuming the employer's worst case scenario, liquidated damages of $600,000, $600,600 for each year, 2 or 3, depending on what your limitations period is. And that's not a bad payday if you consider the $200,000 he's already pocketing with his annual pay. And then on top of that, the FLSA requires the employer to pay a prevailing, employee's attorney's fees, which could dwarf the amount of the back wages owed. So, that's a pretty hefty penalty there based on that analysis that the court determines. But I think their retort to the policy concern about windfalls is, look, the FLSA was never meant to just not apply to highly compensated people. Just because you're highly compensated alone does not mean that you're exempt. And I think that there's prior case law that says that, interpreting the statute, and they rely on that. The second one is that there's going to be cost-based effects on the industry, and if under this interpretation, and the court says, well, the whole purpose of the overtime rule or the salary basis rule is to prevent an employer from trying to do something that is in between a true salary and overtime. So that's the whole point, and those costs are necessarily incurred to achieve that. And then finally, they say, this retroactivity concern. If you put down this interpretation today, like think about how many back wages are going to be owed by employers everywhere. And they say, no, it's not novel. Like this has been part of the FLSA framework since its early days. So nothing new here. We're just telling you what it says, and it's always said. So that's not a valid concern either. So with that, I'm going to pass it to Shaylin to see why the dissents took issue with that analysis.
Thank you, Austin. So dissents are always one of the funnest areas for me to read in opinions. I think they always take a little bit more liberties, and I think that both of these opinions in the dissents are interesting. So the first dissent is by Justice Gorsuch, and no one else joined his opinion. He was alone, but he essentially complained about a procedural issue. He said, this was a bait and switch. Like we were sold on cert that this was going to be a question of how the regulations 601 and 604 apply to highly compensated employees. Do you only have to satisfy 601, or do you have to satisfy 601 and 604? And when we got up with briefing and we started digging into this, we realized that actually everybody is fighting about 602. And we don't even get to the 601, 604 question unless this guy satisfies the 602 salary basis question, which the majority concludes that he doesn't. So I think that this was improvidently granted, and I wouldn't have even reached this decision. The interesting comment that he makes at the end of his dissent is, and you know what's an additional reason why I think that this was improvidently granted? Well, because once we got this thing in front of us, Helix Energy, it started making arguments, not just that the applications were applied incorrectly, but it actually starts making an argument now that the regulations are inconsistent with and unsustainable under the terms of the originating statute. And so they say the statute really only focuses on these duties tests. It doesn't say anything about the salary basis. And he says, hey, you know, that's something that they didn't preserve below, but that's another reason why we shouldn't have even reached this case. We should have left this one for another day. Justice Kavanaugh, who is joined by Justice Alito, in Justice Kavanaugh's view, this one is a super easy, straightforward, simple case, right? He says, under the regulations, an employee who performs executive duties and earns $100,000 per year with a predetermined weekly salary of at least $455 for any working week he works, you're a bona fide executive, right? And you're not entitled to overtime pay. And he says, well, this case, I mean, we've got Hewitt. Everybody agrees that he was doing the executive duties. He was earning way more than $100,000 per year, and he was getting at least $455 a week. End of story. I will tell you, my bias as an employment lawyer that represents employers, I'm like, yes, go Justice Kavanaugh, you're right. Except unfortunately, he didn't get enough people to fight with him. But so that's his position. He's like, this is super easy, very straightforward. This guy satisfied all the things. Why are we talking about this? He does attack the majority opinion in two ways. And he points out, you know, that if you have a worker that is guaranteed at least $455 in any day that he works, like there is no getting around that by definition, then like ipso facto, they're also going to be guaranteed at least $455 for any week in which they work, right? It might not work in reverse, but it definitely, if you're getting $455 for any day that you work, of course, you're going to be getting $455 for any week in which he works. And he points out an interesting thing that I think that the majority does not really pay attention to. And he says, how do I know that this interpretation is right? Well, if I look at the regulations, it says if an employee regularly receives each paid period a predetermined amount constituting all or part of the employee's compensation that isn't subject to reduction because of variations in quantity or quality, then that equals a salary basis. And he says that's exactly what Hewitt was getting here. He was getting $455 in part of his total compensation. And he says the majority doesn't talk about that. And here, not only was he getting $455 a week, this guy was actually making more than twice that. So he said, yeah, of course, if this guy was making less, we might have had a different decision. And so he says, I love this. I'm going to quote it because I think it's fun. The court's contrary conclusion boils down to the head-scratching assertion that Hewitt was somehow not guaranteed to receive at least $455 for any week that he worked, even though, as we all agree, he was in fact guaranteed to receive $963 for any day that he worked. I liked the head-scratching piece there. If I'm going to play foil to Justice Kavanaugh, although I do believe that the majority does ignore that in part, and I think that he makes a good point there, the majority's contrary response to that is, well, yeah, Justice Kavanaugh, but you're conflating two things. You're conflating salary level with salary basis. We all agree that he's getting paid on the right salary level. We just don't think that he's getting paid on the right salary basis. So that's the way that the majority responds to his argument. And then the second piece that he says is, again, as Austin had previously, I think referenced, in his view, 604 shouldn't even apply at all to highly compensated employees. He admits that under 604 that there are some executives making less than $100,000 a year who wouldn't be entitled to overtime pay if they're if they're guaranteed at least their $455 a week, as long as 2/3 of their total compensation comes in the form of the weekly guarantee, then, fine. But in his view, the 2/3 requirement isn't applicable to highly compensated employees like Hewitt. And he cites to a couple of regulations contextually that he uses to support that argument. I thought that the majority's response to that was funny. They essentially just say, well, he says that it doesn't apply. We think he's wrong. And so we're not going to address his arguments. But the last piece of his dissent, and it kind of dovetails again with the end of Gorsuch's dissent. And this is the piece where I'm fascinated to see where it goes. He points out, one last thing. He says, if you look at the regulations, the Fair Labor Standards Act if you look at the statute, the Fair Labor Standards Act on which these regulations that we've been spending all this time on, if we look at that on which they're based, the act focuses on whether the employee is performing executive duties, not on how much an employee is paid or how that employee is paid. So he says, I question whether the department's regulations, which are looking at these things, are even compatible with the statute. And I question whether they'll survive if and when the regulations are challenged as inconsistent with the act. And so this is every practitioner's worst nightmare. When you come up with a really great argument that you failed to make below and you try to make it for the first time on appeal, and this may be a little salt in the wounds for the poor Helix folks who are making this argument, but I anticipate, you have both Kavanaugh and Alito and Gorsuch all in their dissents pointing out that, hey, maybe Department of Labor, you may have overreached when it came to these regulations and including these salary basis and salary threshold tests. And maybe the new challenge is going to be like, we don't even need to look at that. And we just need to focus on whether the job duties are exempt. I know if I'm an employer and I find a situation like this where, oh my gosh, it turns out that we weren't paying these folks in accordance with the salary basis or level requirements, am I going to be thinking hard about whether I make an argument that the regulations and try to challenge the regulations and say that they're not consistent with the statute? Yep. And have the three dissenting justices pretty much like waved a flag and said, bring it on. Yeah, I think they have. So I'm curious to see where that goes. And with that, Austin is I'm going to throw it back to Austin and we're going to talk about, okay, we know that Helix didn't do it right? What could they have done to have avoided this mess? What could they have done to have avoided paying like the astronomical damages that they're looking at facing that Austin had laid out? Austin?
All right. So we already know there's nothing to be done by increasing this guy's salary anymore, right? There's nothing to be done by changing his duties. Those were already satisfied, nothing there. One way to come at this is to pay the guy a straight up salary. Take his $200,000+ a year, break that into the 52-week calendar and pay him on a regular pay period. So that he gets the straight up salary. Then you can satisfy those 602A requirements about, every 2 weeks would be longer than the minimum week period for the pay period. And then you would have a preset, predetermined, fixed salary amount that would not vary depending on the number of days or hours worked. That would be, the straightforward way to solve it. And then another question, a more interesting question maybe is, could they have satisfied 604B, which is the regulation that the court says is the route you should go if you are a daily rate worker. So is there a way to get around, this overtime issue by going that route? And if you'll recall, 604B has the two requirements. So you have to have the guaranteed salary or guaranteed pay, not salary, that is in addition to the daily rate that you get. And then that has to bear satisfy the reasonable relationship test. So the question there, and I think that didn't apply in the case, and Helix conceded that because there was no guaranteed minimum weekly payment at all. So he was just paid straight up on his daily rate, and much less a guaranteed amount per week that had a reasonable relationship to his typical weekly earnings. So can you come up with a way to satisfy that though? What if there was a guaranteed minimum weekly amount? And what if it also bore the reasonable relationship? And one way to do this, Shaylin and I were talking about this, and she asked, well, what if they agreed to guaranteed Hewitt 5 days of work every work week? Would that do it? Like, that's a guaranteed work, and then reasonable relationship. If you go up to the 5 days, that's about a 1.5 ratio, similar to the overtime ratio. Maybe that is a reasonable relationship. If you dropped it down below 5, like say to 2, probably not a reasonable relationship. But this is all with a couple of caveats too. Like, you first, I think, would have to allow this payment of the guarantee of 5 days of work to be a substitute for guaranteed pay. So that's an open question. So like, that's making that assumption that would work. And then also, I think the employer would have to agree that regardless of whether this person worked all of those 5 days, or whether they were even able to provide him with 5 days of work in a given week, given their workflow, he'd still get the payment. That's what would make it guaranteed. That's what would make it the substitute for a guaranteed payment. So perhaps under that, I think, Shaylin's, to her credit that she came up with that idea. But that might be one other potential avenue that could work.
Although I try not to get too cute. I mean, honestly, and I'm going to talk about this in a little bit, you don't get brownie points when you're an employer for trying to come up with novel ways to comply with the Fair Labor Standards Act. If I were advising Hewitt and I got this decision, and my client was saying, I don't want to have to pay this guy $200,000 a year for a bunch of time that he's going to not be working, I would probably be looking pretty seriously at the 604 and trying to come up with some lesser salary that I could pay him that would satisfy 604, and then just make up the difference by paying him the extra based on the number of days that he worked as allowed by 604. But yeah, and I think that those are the two things that the majority opinion had recognized, right? You could either pay him a straight up salary of $200,000 over the whole year, or you could come up with some pay arrangement that would actually satisfy 604. Do you want me? I think it's my turn to take the ball back, so I'll just run with it, Austin.
Sounds good.
So one of the interesting things for me that this case illustrates is sometimes the Fair Labor Standards Act from an employer side can be a little bit frustrating, right? Because here we're talking semantics. This guy made $200,000. Nobody disputes that. And we're kind of figuring out, well, how could we have sliced and diced that $200,000 differently? But at the end of the day, this is an employee who is earning $200,000 a year. But unfortunately, when it comes to the Fair Labor Standards Act, it's not kind of potato. We're not looking at, well, is the substance there, but we might have gotten there a little differently. No. And I've seen this before. Anecdotally speaking, I had a client who found themselves in this situation. They employed truck drivers, and these truck drivers would go and they would pick up something from one location and they would drive it and they would drop it off in another location. And this employer had traditionally paid these employees on an hourly basis. And so when these employees were working more than 40 hours a week, they were getting their overtime, just consistently with the way that the Fair Labor Standards Act is structured. Well, this employer, I should caveat prior to talking to me, this employer decided that, hey, we maybe think about restructuring the way that we're paying our employees. We want to incentivize them to work more efficiently. How can we make them work a little bit more efficiently? And what they came up with is, hey, instead of paying them on an hourly basis, we're going to pay them on a piece rate basis. We're going to pay them per load that they deliver. Okay. But unfortunately, when they set up that pay arrangement, they weren't thinking about, oh, but I still have to track hours and I have to pay these people overtime. So they were just paying them per load. Now, what did that mean? Well, for most employees in this scenario, it actually resulted in a pay increase. It ended up employees being more efficient. They were working the exact same number of hours that they had been working previously when they were under an hourly arrangement, but they were actually, because they were being more efficient, most of these employees ended up getting more compensation under the new compensation structure that this employer had put together. So my employer is thinking this is a win-win for everybody, right? Was it? No. Because as we've learned as employment lawyers, on the defense side, it only takes one disgruntled employee who gets mad about something and goes and files a complaint with the Department of Labor. Department of Labor says, not paying overtime for these folks. Really? Maybe we ought to get in and audit it. And they did. They came in and they audited it. And even though I had an employer who was, they are paying these folks, their employees, more than they would have been entitled to receive on an hourly basis under the old correct payment structure. Yeah, they got tagged for not paying overtime. And as Austin points out, those penalties, they are not nice on the employer side. You definitely do not want to be on the losing end of a Fair Labor Standards Act claim. And another thing that I will say, just again, my own personal anecdotal comment here, is that when it comes to the Fair Labor Standards Act, unfortunately, this isn't something where you can, on the employer side, agree with an employee. Like, we're not going to make those regulations apply. So for in the Hewitt case, it's possible that they could have sat down at the beginning and Hewitt could have said, look, we can either come up with some kind of an arrangement where you'll get overtime, but man, you're working 28 days on, but then you're getting 28 days off. Are you okay with that? Like, would you prefer to get 28 days on, 28 days off, or would you prefer for us to come up with some arrangement where we have to pay you overtime and you might get some kind of a different schedule? Even if that employee comes, even if Hewitt had come to Helix and said, hey, look, you know what, I actually am willing to forego getting the overtime in exchange for being able to get a month off every other month. I'm going to take that. I would prefer to take that. Fair Labor Standards Act is not going to let the employer do that. So unfortunately, you can't get too cute when it comes to Fair Labor Standards Act, is what I have concluded. The interesting debate, I don't know how interesting it'll be, but I said at the outset, right, that the weekly standard used to be 455 and now it's up to 684. Well, next month, we're going to be seeing some new proposed regulations coming out from the Department of Labor. And so I am going to toss this back to Austin to talk about the new regulations. We haven't seen them yet, but is there any speculation about whether we're going to see any impact from this Helix case in these new regulations? What do you think, Austin?
Yeah, so I think these regulations have been long awaited. They've been delayed several times. Again, it's like by the Department of Labor. Their latest projection is May 2023 that they'll be coming out. They think the delay might have been related to waiting to see if inflation would curb and go down. But the gist of it, in terms of the bottom line answer, will Helix have an effect on those, or will they respond to it? Probably not. And I think, as far as I can tell, the consensus of the commentators is that this is going to relate to a hike in the exempt salary threshold. That is going to be the main purpose of this. Again, because, as we talked about, the administration wants to make more employees eligible for overtime. So, as a reminder, the current salary threshold for exempt employees is $684 a week. That's about $35,000 annually. And the DOL's pending proposal is expected to raise that rate to somewhere around $900 to $1,000 a week, which is about $46,800 to $52,000 annualized. And that's a pretty big jump. And I think the Obama administration wanted to get there. It didn't happen. Trump didn't increase it much at all. And then now I think they're trying to get there. And there's been objections by the business community. Many say that exempt employees do not want to be reclassified to non-exempt because they like the flexibility of their hours and their work schedules that exempt status provides. So exactly what Shaylin was mentioning. And then again, like some charitable nonprofits may not even be able to afford keeping employees working the same hours and would be forced to reduce their services. So that's the counterpoint. But all the commentators seem to agree the rate is going to go up probably pretty drastically. It also could include adjustments to the exempt duties test, maybe automatic periodic increases to the salary threshold based on market data. And then finally, for just highly compensated employees, maybe an additional rate increase. And right now, again, like the currently highly compensated employees who earn at least about $107,000 are subject to a reduced duties test, that relaxed standard. But that might go up as well, all again geared towards making more people come within the bandwidth of overtime pay. So I think all the commentators are, telling employers review the salaries that you're paying employees, and then you got a decision to make. Like if you're within that range that it's projected, you got to decide whether you want to pay them more salary, or if you want to convert them to non-exempt and pay them overtime. And that's going to require some planning, and probably best that they started doing that months ago to try to weather the transition. But short answer is it probably will not deal with the salary basis test that was addressed in the Helix decision.
It's really pretty crazy when you think about it, Austin, because as of December 31 of 2019, the weekly threshold was $455. If they crank that up to $1,000 a week, that's more than doubling the weekly salary threshold level in 4 years.
Yeah, and then there's another thing too, just about kind of like status perception about people not wanting to change from white collar to blue collar as a label was another strong thing mentioned. But I do want to switch to kind of like, what does the opinion mean? Like what does Helix, is it going to have a big impact? Is it like a landmark case? And let's get into the fray about that, because you and I may have like some difference of opinion. I think I read it as, applying to daily rate workers. Like you can't satisfy the salary basis test under 602A. Like how many people are daily rate workers? Like, I don't know any, maybe oil rig people, maybe some other people with these odd hitch schedules in certain industries. And it seems like some commentators are saying, well, that's a pretty limited context, maybe doesn't have that much heft. Really, this is just a decision confirming that it's form over substance with the FLSA. It's not how much an employee is paid, but how they're paid. So kind of just an odd way to bring more people within that overtime rule. But let's jump over the fray. Give me your pushback if you have one, or let me know if you agree.
Like, I think daily rate is definitely not the usual form of payment for sure. But I think that nurses, if we're looking at shift-based pay, which the analysis is identical for, I think a lot of nurses and medical professionals in that area are paid on shift rates. So I could see this potentially having some impact in this sphere. I agree with you. I don't think that this one is earth-shattering in terms of precedent. It's just kind of surprising to see somebody who satisfies the executive duties tests and is making over $200,000 a year get classified as non-exempt. That one it feels a little bit wrong for me. I think it will reinforce, though, that again, you can't get cute when it comes to trying to circumvent the Fair Labor Standards Act requirements. I mean, I've had employers, right, that have tried to come in and they're like, what if we come up with this clever argument that we do this and we move people over here, right? And they're trying to figure out ways to avoid paying employees overtime. And the Department of Labor does not like that. They are not fans, nor do they typically receive those types of clever arguments well. And the Supreme Court the majority has certainly backed them up on this piece. I do think a bigger takeaway that we may see in the coming years, like in the next couple of years, is a head-on challenge. Like Justice Kavanaugh has pretty much just invited people to do, right? Maybe what we'll ultimately see is this court throwing out the salary basis and salary level requirements altogether and just focusing more back on the job duties. And if Congress wants to set some kind of a monetary threshold, then Congress may need to get involved. But certainly interesting. I nerdily think that these types of cases as an employment lawyer, these are the things I think are fun to look at.
Yeah.
Well, do you think there will be an increase in litigation because of this case, with the people in those environments now saying, hey, I haven't been getting overtime?
Yeah, I think that you could definitely see that for sure. And certainly if I'm an employer and I've failed to comply with this, I'm going to be trying to challenge and take the the potential Kavanaugh out too. So yeah, I do. I think that you could definitely see an uptick for people who are paid in non-traditional ways, looking at this decision more closely. As Austin said, I mean, it's, plaintiffs are going to be really excited. Plaintiffs' lawyers should be really excited about getting these types of cases. There are some pretty big damages if you violate it.
But what about the 602 argument that Gorsuch made, that this really wasn't supposed to be, they really argued something that they hadn't presented?
Yeah, I think from my view that ship has sailed. I mean, maybe there was an argument there, but the majority has clearly answered that question, and it's going to be binding going forward.
Do you think that will minimize the impact of 602 in other situations?
I don't know. What do you think, Austin?
I don't think so. I mean, I think they framed the issue how they did. He can object that it was improperly granted, but it was decided. So I think their interpretation will stand.
Yeah, I'm with Austin. I don't think you're going to see a lot of changes too in the regs that are coming out. I don't think that the Department of Labor is going to have seen Helix's argument and have been, swayed to the other side. I think that their regulations are pretty ingrained.
Yeah, if anything, I think, this retroactivity concern is a real one. And with those kind of back pay damages, you're going to get litigation over that. Employers trying to get out of it and bringing that fight to the forefront that Kavanaugh teed up.
Sorry.
Oh yeah, just that the regulations can't do this. It's not part of the statute, and it's not part of the regulatory authority. So they're inconsistent and should be changed.
I question whether you might see some gratuitous references in these upcoming regulations in the comments in the Federal Register, right, as to why they are authorized under the statute to implement a salary basis and salary threshold. Trying to bootstrap and suspenders it in anticipation that they're going to get this challenge. So,
do you think you'll see a lot of employers making compensation decisions new and changing existing employees' compensation structure because of this?
I think that you definitely will when you see these new regulations come out. I mean, we saw it when the last set of regulations came out and significantly increased the weekly threshold. I think that if you're an employer and you are paying an employee on a salary base or on a daily rate or a shift rate that falls under 604, I think that you would be very wise to take a hard look and make sure that you really are satisfying 604, and particularly with regard to the reasonable relationship requirements, because it's not a common pay structure. But when you see a case come out like this and the ramifications, the potential negative ramifications, I think that every employer would be well advised to make sure that however it is that they're paying their employees in these sort of non-traditional avenues, that they do comply with the regulations, and particularly if you're paying paid daily rate, shift rate.
Great. Well, our time is up. Thank you guys so much for doing this presentation for us. It's technical, but fascinating. And these little technical issues can really trip up an employer, a small business employer that probably doesn't pay as much attention to these kinds of things as like a global employer does. But I appreciate you putting the time into this. I know it takes a lot of time, and I'm grateful that you did this presentation for us. So thank you. And to those of you that were watching, we will send the CLE certificate sometime next week, along with other materials. If you have ideas for new topics that you'd like to see, just email me at lori.nelson@law.utah.edu, and we'll put on those programs for you. Thank you so much to everyone, and we'll see you next time.